It's nice to talk to you today for the Protecting the Vulnerable and the Role of Lawyers Legal Strategies Against ICE Abuse program. My name is Alicia de la O. I'm the Director of Legal Access and Information at the Commission on Immigration. Dora, do you want to go ahead and introduce yourself?
Yeah, I'm Dr. Dora Schriro. I proudly tell folks that for some number of years I've been a jailer, but I've always been on the side of doing the best for all the people in our care and custody.
Yes.
And I'm sorry, I'm very proud to say that for a number of years now I've been in a variety of volunteer capacities within the Commission on Immigration at the ABA.
Yes, you've also created some great resources that are going to be included as part of this program. So today we're going to go over some of the standards of detention and who is authorized to detain somebody for immigration enforcement. So Dora, can you let us know who can apprehend somebody and detain somebody for immigration enforcement?
Yeah. First, there's CBP, Customs and Border Patrol, which is one of a number of sections within the Department of Homeland Security, and they are charged with maintaining border security, and so any apprehension and detention that they would be involved in would be limited to the border. And then specifically to the interior of the United States, another of the large units within DHS is Immigrations and Customs Enforcement, also known as ICE. And so they're responsible for enforcement inside the borders, and so the interior of the United States.
Great. So let's go ahead and start with CBP. What are the standards that apply when CBP holds somebody in its custody?
So CBP they have if you will, a lighter touch. They are authorized to keep someone in their custody not very long, but not to exceed 72 hours. And the guidelines that CBP follows is in a set of standards that CBP promulgated back in 2015. It's in its length known as the National Standards on Transport, Transport, Escort, and Detention and Search. Say that real fast. Otherwise known as TUDS, and I guess that's why they call it TIDS. And that is an agency-wide policy that sets forth all of the nationwide standards that governs CBP's interaction with all of those who are in its custody.
And the TED standards are linked in the materials to this program. So moving on to ICE, what is the difference between an ICE hold and when ICE houses somebody long term?
Yeah. Forgive me. Let's to just double back to Ted's. If there's like a baseline set of expectation, the one that Ted sets is that every effort must be made to promptly transfer, transport, process, release, or repatriate that individual as appropriate and operationally feasible. Operationally feasible is one of those squishy terms which gives government quite a bit of discretion, and discretion is something we'll be talking about this morning. And so
Absolutely.
now I'm sorry to double back to your question about ICE.
Absolutely. Thank you for including that information. And to talk a little bit about ICE now, what is the difference between an ICE hold and when ICE houses somebody?
Yeah, so language is everything. A hold is something that is, as the word would suggest, is short-term versus housing, which is likely to be, or could be, longer term. And with Um, with ICE, they have undergone a recent change, purportedly to be temporary, and that was a memo that was issued um, nationwide to all of the field office directors, advising that that the previous expectation that a hold in the context of ICE, which was previously no longer than 12 hours, could now be as much as 72 hours. And there's even some squish in that would be the goal, but it appeared that it could even exceed the 72 hours.
And so would that include their discretion to make that decision?
Well, it would be discretion. I would like to think, but I imagine it's going to vary considerably, field office by field office, what the local policy and practice is. But having served as a warden and as a commissioner of both city and state correctional systems, and having overseen activities at ICE as well in the course of my career. Um, there's uh, there's discretion, but there's also under the best of circumstances, individuals trying to make the most of managing conditions that are largely out of their control. I'm just back from having done site inspections at several facilities in another state. These are ICE detention facilities, and um, the throughput, if you will, the number of people that are now coming into that facility and the number of people that are going out of that facility is changing very rapidly. And as you would expect with all the enforcement activities, it's the numbers that are coming in are appreciably higher than the numbers that are going out. And so uh, how much control one has over that is sometimes out of their hands, and so that's certainly true on the correction side. But unless there's some really remarkable enforcement or some critical incident that pops up, it's less likely to happen on the DOC than it is with ICE.
So to talk a little bit more about ICE holds, what are the standards that would apply when ICE is just holding somebody?
Yeah, so the if you go back to TEDS at the beginning of TEDS, it talks about the doing the best you can as fast as you can. It doesn't specify hours or days. When you go further into the TEDS document, there it identifies and again, always with a caveat, not to exceed 72 hours, given within the control of that particular field office. And so in both instances, there are no hard and fast. And I imagine that's because if there is then litigation about exceeding a specific number would be greater than it is now.
Okay. So switching over then to what are the standards that would apply when ICE houses somebody long term?
Yeah, so long term, anything more than 72. Well, let me just also add on the ICE side, the expectation has always been that when you're admitted into the facility, that within 12 hours you shall be assigned to a bed, and so a housing unit in which that bed is located. And so there has to be a lot that happens in intake, and that's where a lot of very important things happen. Most importantly, what are the special medical or mental health requirements that that person may present upon admission, as well as what are their custody requirements? Are they likely to be an aggressor or to be someone more susceptible to abuse or neglect of some sort if left with people that are a higher custody than they.
Okay. And so then once the intake process occurs and somebody is being housed in an ICE detention facility, what are the standards that would apply? Are the detention standards that
Yeah.
they would be
So
subject to?
here again, ICE has undergone some considerable change, and I might also mention that this is not in all instances specifically to be attributed to the current administration, but work that was also in process towards throughout the previous administration, and so they're all coming to fruition, if you will, about the same time. So at this point in time, there are only several ICE detention standards in effect. And those are basically what are called PBS, performance-based standards. And the more recent was first promulgated in 2011 and then parens revised in 2016. And I've always characterized them as the better of the standards, even when there were a greater variety, which has now changed. The PBS NDS 2016 revisions reflect not only industry standards in the field of corrections, and of course there are appreciable differences, market differences between people held in a civil versus a criminal situation, but the criminal standards have undergone much more litigation, and so they are more fine-tuned and more deferential to the conditions that someone in custody would have. And so that's why I say that they are the better of what was the several that were just recently in effect. The other set of standards that are now expanding considerably, which is also of concern to me, are the NDS, or the National Detention Standards, and their history was once very promising. They were promulgated by INS before DHS was created, and they were also predicated on correctional standards for a pretrial population, which are the most deferential. But what has happened first in the previous administration and now and continuing now with the NDS is that they are being stripped of many of the specifics that one would use to evaluate compliance. And the narrative at the beginning of both the current set of standards and a new revision, which will go into effect sometime soon, is that they say that these standards are specifically for facilities that are operated by correctional systems, and especially pretrial systems, jails. And so while people who are pretrial have more rights than people who are incarcerated, by being deferential to sheriffs to fill in all the blanks, our experience has been that detainees held in these smaller systems by locally elected officials, by and large, tend to experience more difficulties, both because of the way the standards are set up, and then when you have two or more populations in a facility, the sheriff's prisoners and then the ICE detainees, that all too often the ICE detainees, in my opinion anyhow, get the short end of the stick. And so you have standards, but the strength of the standards is blunted by the deference given to the jail operator.
Wow. And the where somebody can find which standards apply to which facility is also linked in the materials to this program, because each facility has different standards, right?
Yes.
Okay.
And as I mentioned, those standards are now in flux.
Right.
But there'll be fewer sets of standards, which on the surface is a good thing because everyone should be afforded the same rights. But when the consolidation means that those rights are then diminished because of the tilt in another direction, then that's something that certainly warrants our continuous oversight.
Absolutely. And that leads me into my next point. I want to provide an update on the litigation involving the DHS oversight offices. The Homeland Security Act of 2022 created 3 offices within DHS to protect individuals' rights and interests, and those are considered the DHS Oversight Office. That's the Office of the Immigration Services Ombudsman, the CIS Ombudsman, the Office for Civil Rights and Civil Liberties, CRCL, and the Office of the Immigration Detention Ombudsman, OIDO. I'm going to focus on CRCL and OIDO for today's program. CRCL is required by statute to receive complaints of civil rights and civil liberties abuses by DHS. That's pursuant to 6 USC 345. And OIDO is required by statute to take complaints that allege violations of law and professional standards. They are also required to conduct on-site inspections of immigration facilities and to assist those affected by misconduct, excessive force, and violations of law or detention standards. And that's pursuant to 6 USC 205. This year, pursuant to the executive order called Implementing the President's Department of Government Efficiency Workforce Optimization Initiative, long name, on March 21st of this year, DHS effectively closed the DHS oversight offices, including CRCL and OIDO. And on April 24th of this year, the RFK Center for Human Rights and the Southern Border Communities Coalition filed a suit in the District Court for the District of Columbia, challenging that action. And so while DHS has limited their workforce, throughout the litigation, they have maintained that the DHS oversight offices are funded and still meeting their statutory duties. So, as such, attorneys and pro se individuals should continue to submit their complaints to CRCL and OIDO. And the way an attorney can submit a complaint on behalf of their client for a violation of the detention standards, as I was mentioning, CRCL and OIDO are both options. They both have online complaint forms that can be submitted, and then engagement can occur, via phone, email, or postal mail. But besides CRCL and OIDO, there are other offices that also accept complaints. One of them is the DHS Office of the Inspector General. They investigate fraud, waste, abuse, and criminal misconduct involving DHS programs and personnel. This would include USCIS, CBP, and ICE. Examples of misconduct that they investigate include border corruption issues, DHS employee criminal activity, misuse of classified information, and bribery or acceptances of gratuities. Another office that exists is the ICE Office of Professional Responsibility. They manage and investigate allegations of employee misconduct. And lastly, there's always the Detention and Reporting Information Line, DRIL, which is now an online complaint form that can be completed as well. There is a one-pager that accompanies this program with more details and links to these online complaint forms. Thank you so much for being here for this program today, and thank you to you, Dora.
My pleasure.